Hello again, Summerlin agents. Tim is here. Page 6 of the RPA, paragraph 13. Federal fair housing and compliance and disclosure. All parties are offered without regard of race, color, religion, sex, national origin, age, gender identity or expression, family status, sexual orientation, ancestry, or handicap, and any other current requirements of federal or state law, fair housing laws. 14. Walkthrough inspection of property. Buyer is entitled under this agreement to do a walkthrough within blank calendar days. 3 is the magic number. Prior to close of escrow, to ensure the property and all major systems, appliances, heating, cooling, plumbing, electrical systems, and mechanical fixtures are as stated in the SRPD, and that the property and improvements are in the same general condition as when agreement was accepted by the seller and the buyer. To facilitate the buyer's walkthrough, seller is responsible for keeping all utilities on, including all operable pilot lights. If any systems cannot be checked by buyer on walkthrough due to non-access or no power, gas, or water, then buyer reserves the right to hold the seller responsible for defects which could be not detected on a walkthrough because of lack of such access or power, gas, water. The purpose of the walkthrough is to confirm A, the property is being maintained, B, repairs if any have been completed as agreed upon, and C, seller has complied with the seller's other obligations. Now, more bolded wording. If buyer elects not to conduct the walkthrough inspection prior to the close of escrow, then all systems, items, and inspections and aspects of the property are deemed satisfactory, and the buyer releases seller's liability for costs of any repair that would be reasonably been identified by a walkthrough inspection, except as otherwise provided by law. What this means, gang, you do not waive the inspection. You never waive the inspection, okay? The buyer or a buyer's representative has to be physically with you on the walkthrough. We'll talk to you more about this in the training, but that area is very important. Delivery of possession. Seller shall deliver the property along with keys, alarm codes, garage door opener, controls, and if freely transferable parking permits and gate transponders outside of escrow upon close of escrow. Seller agrees to vacate the property and leave the property in neat and orderly, broom clean condition and tend to possession no later than, you have a choice. You check off close of escrow date, or you can put another date in here. 17 years, I've always checked off close of escrow, so that's what you're going to check off. In the event seller does not vacate the property by this time, the seller shall be considered a trespasser in addition to the buyer's other legal and equitable remedies. Any personal property left on the property after the date indicated in this section shall be considered abandoned by the seller. 16. Risk of loss. Risk of loss shall be governed by NRS 113.040. This law provides generally that if all or any material part of the property is destroyed before transfer of legal title or possession, seller can enforce the agreement and buyer is entitled to recover any portion of the sales price paid. If legal title or possession is transferred, risk of all shall shift to the buyers. 17. Assignment of this agreement. Unless otherwise stated here, and this assignment is non-assignable. I repeat, non-assignable. I repeat, non-assignable. We'll talk more about this as your career moves forward, unless agreed upon in writing by all parties. 18. Cancellation of this agreement. In the event that this agreement is properly canceled in accordance with their terms contained herein, the buyer is entitled to a whole refund of the AMD, referenced in Section 1A, by a fully cooperated and executed cancellation of escrow instructions. Neither buyer nor seller will be reimbursed for any expenses incurred in conjunction with due diligence, inspections, appraisals, or any other matters pertaining to the transaction unless otherwise provided herein or except as otherwise provided by law. 19. Default. Mediation. Before any legal action is taken to enforce any term or condition on this agreement, the parties agree to engage in mediation, a dispute resolution process through a mediator mutually agreed upon by the parties. Mediation fees, if any, shall be divided equally among the parties involved, notwithstanding the foregoing in the event the buyer finds it necessary to file a claim for specific performance. This section shall not apply. Each party is encouraged to have an independent lawyer of their choice review this mediation provision before signing thereto. By initialing below, these parties confirm that they have read and understand this section, voluntarily agree, and provisions thereof. Basically, if you get into a dispute about anything, earnest money, about the cancellation of the contract for whatever the reason might be, before you hire lawyers and spend a lot of money, both parties should agree to mediation. It's cheaper, less expensive, and usually agreements can be made where it's a win-win situation and you don't have to get attorneys involved and spend a lot of money, okay? As we go through here, Now, B, if the seller defaults, in performance under this agreement, buyer reserves all legal and or equitable rights, such as specific performance. That's the key word, gang. Specific performance against the seller. And the buyer may seek to recover a buyer's actual damages incurred by the seller due to the seller's default. This doesn't happen a lot, but it's a week before escrow. Everything's going great. You get a call from the listing agent. Hey, Tim, it's Ricky at Remax. My seller changed their mind. They don't want to move. How come? I don't know. They don't want to move. I'm really sorry. The deal is dead. Your buyer's going to be upset. Your buyer's only recourse is to hire an attorney potentially to sue the seller for what I mentioned earlier, specific performance. Okay? It's a dirty thing. If the seller does that, again, in my career, it's happened once. Not very common. Sellers list the property. They want to sell it. Okay? Now, if the buyer defaults, not the seller, if the buyer cancels. If buyer defaults in performance under this agreement, as seller's sole legal recourse, seller may retain as liquidated damages the EMD. In this respect, the parties agree that the seller's actual damage would be difficult to measure and that the EMD is in fact a reasonable estimate of charges that the seller would suffer as a result of the buyer's default. Seller understands that any additional deposit not considered part of EMD in Section 1A herein will be immediately released by escrow holder to the buyer. So your buyer cancels, day 27 for whatever reason, okay? If it's past the due diligence period, they're not going to get their EMD back, okay? If they cancel because the appraisal has an issue, both parties can't renegotiate, your buyer is entitled to their money back. Your buyer cannot get a loan. We thought they could. Your lender said they could get approved, but now something's gone wrong. As long as they can get a denial letter from the lender before that loan commitment time frame expires, which is typically 27 days, they're entitled to their EMD back, okay? And again, at the bottom of each page, each party acknowledges that they have read, understood, and agrees to each provision of this, unless a particular paragraph is otherwise modified. In addition, an addendum or counteroffer. Derek Jeter, initials, page 6 of 11. Stay tuned, gang. Page 7 is coming.